Black Laws, the 9th edition. Fundamental law. The organic law that establishes the governing principles of a nation or state, especially constitutional law. Fundamental law is also termed organic law, ground law, natural law. Black Laws, the 9th edition. Organic law. The body of laws, as in a constitution, that define and establish a government. Fundamental law. Black Laws, 9th edition. Natural law. A physical law of nature. A philosophical system of legal and moral principles purportedly deriving from a universalized conception of human nature or divine justice, rather than from legislative or judicial action. Black Laws, 9th edition. Ground law. A fundamental law. See fundamental law. If the power of a sovereign or of a government is limited by a ground law, written or unwritten, a treaty cannot override that constitution. Fundamental. Serving as an original or generating source. Primary. Serving as a basis supporting existence or determining essential structure or function. Of or relating to essential structure, function, or facts. So we're looking at the definition of fundamental law. What is fundamental law? What is its operation? And how does it affect us, this fundamental law? Now, when we look into legal dictionaries, legal definition of what fundamental law is, it states that it is the essential structure. It is the foundation. And it is the determining function of the laws of a state party. Now, fundamental law is based upon or originates from natural laws and organic laws and something else that we know as ground laws. Now, these natural laws, organic laws, and ground laws, which are the determining function of the state party, that fundamental law, has to be expressed, it has to be expressed in the constitutional law of that state party. And this constitutional law, it brings forth, it shows the governing principles that the state party is bound to. So the constitutional process here in Canada is founded in natural, organic, and ground laws. And these laws are the foundation of this state party. So whatever rights or freedoms these laws produce, they have to find their expression in the constitution law of the state party. So we have those fundamental laws, and those laws are the governing principles that a state party must follow. And those fundamental laws have to be found or brought through the Constitution law, the Constitution Act of that state party. Now we know that fundamental laws include natural laws. And when you look at the definition of a natural law, it is principles that are coming from universalized conception of human nature or divine justice. This is where natural law comes from. It comes from universalized conception or universally recognized rights, such as the UDHR, or divine justice. Now, this is separate to statutes, enactments, and regulations. These are natural laws, and these natural laws must find their expression in the constitutional laws of that state party. Now, fundamental laws also include organic laws. And organic laws are a body of laws that define and establish government. So these organic laws and natural laws have the effect of defining and establishing and governing the government. And they must find their expression in constitutional law. Foundational or fundamental laws is not statutes, enactments, or regulations. Fundamental laws are solely or strictly organic law, natural law, and ground law. So we are seeing that natural laws, fundamental law, are universally recognized laws. And these laws are recognized through human nature or through divine justice. Now, natural laws find their expression in the Universal Declaration of Human Rights and subsequently in the International Covenants. If you read and study the International Covenants, you will for sure see organic law, ground law, and natural law very prevalent within these covenants. The reason why they made up these covenants was for that very reason, to protect natural laws. Now, subsequent to that, we find these natural laws, their expressions in our constitutional process. We know that the international covenants clearly state that Canada had the obligation to bring forth the rights and freedoms that were present, that were enumerated in the international covenants. They had to bring it forth in the constitutional process, and they did. But even greater than that, we understand that the constitutional process is an expression of our natural laws, our organic laws, our fundamental laws. And these laws are applicable to us as human beings, and they flow from our human nature, from the rights and the understandings that we gathered together over the generations. And they find their expression here and here. Black Laws, 9th edition. Ground law. A fundamental law. See fundamental law. If the power of a sovereign or of a government is limited by a ground law, written or unwritten, a treaty cannot override that constitution. We're looking at ground law as defined in the legal world. Ground law is a fundamental law. We know that's a natural or an organic law, and that it is a foundational process. Now, ground law is the power of a sovereign or government that is limited. Limited by ground law. Now, this ground law can be written or unwritten, and it cannot override the Constitution. So our rights and freedoms that universally find their expression through human nature, that are recognized in international covenants and in domestic law, they find their expression and they are protected through ground law. Because it is a fundamental law, these rights and freedoms. And these fundamental laws, these ground laws, they cannot be overridden. They cannot be surpassed by the government. They don't have the right to ignore them. They don't have the right to look the other way. They don't have the right to not allow you to operate under this fundamental law that is present in their constitution. So ground laws cannot be overridden by a constitution. So for example, everyone has the right to recognition as a person before the law. This is a natural right. This is an organic law. This is a fundamental law. And the state party where you are living do not have the power, or are not exposed to have the power, to be able to override that ground law upon you as a human being. Black Laws, 9th edition. Natural right. A right that is conceived as part of natural law, and that is therefore thought to exist independently of rights created by government or society, such as the right to life, liberty, and property. See natural law. Black Laws, 9th edition. Inalienable right. A right that cannot be transferred or surrendered. especially a natural right, such as the right to own property, also termed inherent right. A natural right. Natural rights is something that we all have. Every single one of you who are watching this video now, you possess, you have, within you, around you, you can exercise natural rights. And this is a right coming from natural law, coming from organic law, coming from ground law. It exists independently of rights created by government or society. So your natural rights stem from natural law, and they are independent of any rights created by government or society. Now we know that there are two operations of law that are going on within the Constitution Act of Canada or within law generally. People tend to say that there is common law, and then that there is statute law or enactments. Now, these two laws, one is natural law, natural, it's foundational law, and one is enactments. Now, this natural law applies to the human being. It's there for us as human beings, as men and women. These laws here, for statutes and regulations, they apply to the incorporated person, the legal person. And that legal person is given certain rights and freedoms. Now, that legal person is also given civil rights. Civil rights. So we have natural rights under foundational law that affect us as human beings. And then we have civil rights that go for that incorporated being. Civil rights, they stem from, or they come from, starting of Roman law, and ecclesiastical law, church law. This is where civil rights come from. Black Laws, 9th edition, ecclesiastical law, the body of law derived largely from canon and civil law and administered by ecclesiastical courts. The law governing the doctrine and discipline of a particular church. Ecclesiastical law. This is law that is derived from canon and civil law. Ecclesiastical law is law that is governing the doctrine and discipline of a particular church. When you refer to God's laws, for example, this is ecclesiastical law. Most people claim that God's laws flow from biblical authority, the Bible, and it's canon. Now, ecclesiastical law comes from, or is derived from, canon and civil law. What are we missing here? Ecclesiastical law is not derived from, does not come from, does not include fundamental law or natural law, organic and ground law. Here, in the description, it would say ecclesiastical law is derived from, and then it would have to state one of these designations in order to include this type of rights and freedoms within ecclesiastical law. It doesn't. It clearly states that these laws stem from canon and from civil law, not from fundamental law. Now, there's a reason for that. In ecclesiastical law that comes from canon and civil law, what do we find in this law? What do we find in this structure? We find that there is the governed. We find that there is subjects and servants. We find that there is laymen and clergymen. This type of law here brings forth the subject and servant. It brings forth the different classes of individuals. For example, if you follow Canaan, if you follow biblical scripture, then you are taught that you are not wise enough to understand God, and that through the Canaan scripture God has left you individuals, apparently, who will teach you how to find him, and you must submit to them. So there, the submission is brought out. You subjecting yourself to another. You submitting yourself to another. And in civil law, we understand that civil law is all about subjection. They, in present day, have rendered us that incorporated being, and they are trying to control us through the enactments, statutes, and regulations. Now, there is also foundational law. And this law is our natural law, organic law, and ground law. And never the two shall meet. Never the two shall meet. Because in this law here, we find our expression and our freedoms, our rights and freedoms, our fundamental rights and freedoms, as enumerated in the Universal Declaration of Human Rights, as enumerated in the International Covenants, as brought forth in Canada's Constitution Act, per the obligation. The fact that these expressions of law must be included and must be allowed to operate, and no one has the right to remove them. However, on this side, through civil law, or if you choose to use canon law, biblical law, they can prescribe your actions. They can limit your actions. As being rendered that juridical personality, that legal person, our natural laws and organic laws have been removed. They have been stripped from us. And they try to not allow us to operate in this capacity. However, there is no obligation upon us to enter into this capacity and to accept this legal structure, this operation of law that is going on, that is creating different classes of persons, that is not promoting equality, and that is saying that there is kings and queens and those that we must serve, those that we must pledge allegiance to. Divine law. Law that emanates from a supernatural source, such as a deity. See natural law. Divine rights of a king. The political theory that the sovereign is a direct representative of God and has the right to rule absolutely by virtue of royal birth. When we look into the word or expression divine law, it states that this is law that emanates from a supernatural source, such as a deity. And then they go on and quote, they say, see natural law. So divine law is organic law. It's ground law. They claim that it emanates or comes from a supernatural source. But they don't state, and they don't bring the correlation to say that this is ecclesiastical law. They make the distinction to say that it's not canon, or civil law. That it is natural law. So those who refer to divine law and say, I am invoking my divine rights to freedom, what you are actually calling on or declaring is those fundamental laws, those organic, ground, natural laws, which produce your rights and freedoms. Some people think by saying, I'm calling on divine law, that what they are trying to call forth is ecclesiastical law. Laws that come from the Bible. Freedoms or rights that come from the Bible or from civil law. And again, never the twain shall meet. Never will they meet. Because when you're talking about civil law, canon law, ecclesiastical law, never once does it ever mention the fact that this type of law deals with natural, organic, or ground laws. And these natural, organic, and ground laws are where our human rights and fundamental freedoms, our common law rights, if you will, find their expression. And as you saw through this video and other videos that I've done, there's an obligation upon this state party termed Canada to make sure that fundamental laws, the expression thereof, the rights contained thereof, are expressed in their constitutional act, which they did. Divine right of kings or queens, if you're here in Canada. The foundational law that the sovereign, oops, sorry, my mistake. I thought I said the foundational law. The political theory. Let's stop there. For anyone to claim kingship or queenship, It falls under a political theory. And this divine right of kings states that the sovereign is a direct representative of God and has the right to rule absolutely by virtue of royal birth. Where is all this junk coming from? Is all this junk coming from foundational law, from natural law, organic law, or is all this political theory that a sovereign is a representative of God and has the right to rule absolutely by a royal birth, coming from ecclesiastical laws? Canon, scripture, biblical scripture, civil laws. We know in foundational law, no one has the right to place us into servitude. We know in foundational law, we don't have to take recognition as a person. We know in foundational law, we don't have to pledge our allegiance to a sovereign. However, in civil law, in ecclesiastical law, they claim a divine right of kings. And they say that this political theory we must submit to, and that they become the sovereign by being the representative of God, and they claim to rule absolutely over us. Again, one, fundamental rights and freedoms coming forth through natural law, from human nature, from personal understanding of men and women over generations of living, and another coming from scripture, canon, creating civil laws, producing subjects and servants by a human being claiming a divine right. I'm a representative of God, and saying you must serve me and subject yourself to me. Again, all these foundational laws, they were brought forth, the natural laws that a human being, a man or a woman, is entitled to, has the right to claim, if you will, and the state party must recognize. All these foundational laws were brought forth in the Universal Declaration of Human Rights and in the international covenants. But also, in those covenants were brought forth part of this junk here. Prescription law. That you can be controlled by rendered a subject or servant, and that you have to follow and obey that sovereign of your state. The Parliament of Canada, a website from Canada, the government, it states that Canada is a constitutional monarchy since 1534. Black Laws, 9th edition. Monarchy, a government in which a single person rules, with powers varying from absolute dictatorship to a merely ceremonial. A limited monarchy, a monarchical form of government in which the monarch's power is subject to constitutional or other restraints, also termed constitutional monarchy. Canada is a constitutional monarchy. It's a government whose power is limited and controlled by constitutional or other restraints. That's what a constitutional monarchy means. The power that the sovereign has in this government is limited by the constitutional or other restraints. Now, what is the Constitution here in Canada? It is foundational law. It is natural law, organic law, ground law. This law is what constrains, is what places limits upon how this government can treat you and must deal with you. Your fundamental rights and freedoms are preserved and are present there. However, they don't want you to operate under that foundational law, those natural rights, those natural laws. They want you to stand as a subject servant under ecclesiastical law, under a political theory of divine right of kings. So the Queen can claim that you are her subject and therefore rule you through enactments and legislation. However, you do have the right to exercise your natural rights, your natural freedoms. which again are expressed in international law and in the foundational law, the Constitutional Act of Canada, right now.